हमारे बीच प्रेसिडेंट केरला बार एसोसिएशन परम आदरणीय एडवोकेट यशवंत सिनॉय सर है। मैं उनसे निवेदन करता हूं कि कृपया वह पोडियम पर आएं और अपने विचारों से हम सबको अनुग्रहित करें।
Warm good afternoon to all the dignitaries on the dais and off the dais. And I apologize for my name. It's Yeshwanth Shenoy, but I'm not Yeshwanth Varma. Actually, I do not want to take too much time of yours because I know the lunch is awaiting us. But again, today, why we are sitting here is because of three words. Three words, and those words are independence of judiciary. Jaj साहब ने जो बोला है, ठीक बोला है. हमारा issue transparency नहीं है, accountability नहीं है, but it is independence of justice. You know why I'm talking about independence of justice? Today, if an FIR is not registered against Yeshwanth Verma, you know why it is not registered? It is not registered because of the Supreme Court's verdict in 1991, Justice Veeraswamy case. They said an FIR against the sitting judge can be registered only with the permission of the Chief Justice. And even when the President normally works on the advice of the Council of Ministers, but when it comes to registration of FIR or sanction of a judge, it is the opinion of the Chief Justice that matters. Who did it? The Supreme Court did it. Who did it? Independence of judiciary did it. So you have to understand all our judges' cases, right from Keshwanand Bharti case, we were speaking about independence of judiciary being a basic structure, and thereafter took that thing to remove the executive interference and took over the entire thing to the collegium. And who is this collegium? Again, inclusivity of the collegium. I always used to compare collegium to the election of the Pope, because election of the Pope is one of the most secretive procedure in the world. But let me point it, the collegium system beats it hands down, because, let me put it why. In the High Court of Kerala, we are having 47 vacancies, 45 is filled. But when it comes to collegium, it's 3 of them. Not even the other 42 gets to know who are the 3 of them. That is why every judge on the bench, once he is out, has criticized the collegium, because collegium is not at all an inclusive procedure itself. It doesn't include the entire court itself. Where are you speaking about including others? And I know there are speakers who said, ek taraf kuwa hai, ek taraf khai hai. Now what is the middle path? The middle path is to involve the bar. And again, I am not saying you involve the bar for no reason. You involve the bar because the Supreme Court itself has said that independence of judiciary includes independence of the bar. Kisme bola? Muthu Krishnan versus Registrar General of High Court of Tamil Nadu, Madras High Court. There, the Supreme Court itself says that independence of bar is at par with independence of judiciary. Therefore, if you are considering the bar to be a part of the judiciary, why not involve the bar in electing your judges? In electing your judges. The second case again, which went, how did this in-house procedure come? Abhi 3 judgeon ka committee bana, kahan se bana hai? Under what? It is Ravichandran Iyer versus Justice A.M. Bhattacharjee. 1995 case of Supreme Court, where the court says, see, impeachment is a tough procedure. We need to find something before impeachment, and they brought in this in-house procedure. Has it been successful? No. But 2 of these judgments, one is Veerasamy, other is Ravichandran Iyer. These 2 are the hurdles in our path. And both of them are based on independence of judiciary, which is an undefined term. If anybody is asked this question, can you define independence of judiciary? Answer is no. And the answer comes from Justice Jha, who spoke before me, who says independence of judiciary is a shield that we keep to come out of all our dirty affairs. So that is exactly where, when we are sitting here, who are all presidents here, and the members of the Advocates Association of the High Court, remember this one part. Today, in the beginning of this conference, when I came here, this hall was empty. The first thought that came to my mind was it worth coming, traveling all the way? Because I have traveled the farthest. I am the youngest in the bar, I have traveled the farthest. And sometimes this question comes, are people with us? Are people with us? And today, let me point out, seeing this crowd sitting here without lunch, I know that this crowd is with us. This crowd is with us, and this is a historical moment. This is a historical moment because never in the history has all the Bar Association presidents come here. And then I am pointing out what Advocate Pracha said. Please see all those members who are not here, take down their names. It's important. I'll tell you why it is important. I became the Bar Association president because I have never been a leader in a classroom. I have never been an executive committee member of the Bar Association. I went straight for the president. You know why? I was the chosen one. Chosen one in the sense, I had nothing to do. I thought like those middle class families where our parents tell, don't go into those things. Those are not your cup of tea. Stay here, do your work, go home. That is the way our parents, the middle class parents, have brought us up. So I was doing my work, and one judge decided that she will take a contempt against me. She thought I will come with an apology letter, but instead I filed 3 writ petitions and 1 contempt petition against a sitting judge of the High Court of Kerala. And then I stood for elections, not for anything else, but to give her reference speech because she was retiring that year, and I wanted to give the retirement speech. I won that election with 84 votes, just 84. Next year, I again stood for election. That time, I won with 800 votes. Now, that is exactly where the bar, this time, the bar, all these presidents that you see here, they have come here because at the beginning of this function, somebody was speaking about courage. What is courage? Courage is this. Because let me point out one thing. What you may or may not know, as the secretary of the Rajasthan Bar Association said, when he was on his way here, they were asking, you are young, do you want to sacrifice your career for this? And he still came. And the fact, all of these people who came here gives one different thing. The current is changing. The bar is changing. It is all youth that we are speaking about. Youth do not want face value, they want justice. Youth doesn't want a handful of advocates to take over the entire high courts. It has happened in the past. It has happened in the past because of which these kind of judges are there in the bench today. It will not happen in the future because these are the kind of presidents sitting here who do not care for what happens to them. They care for you lawyers, everybody, because what we want is we want a level playing field for everybody. Level playing field for everybody. So that is exactly what we want to do today. And if today we have to take any resolution, I'll point out that these bar associations have to do only 2 things. One, file a writ petition. After filing an FIR, it will not be registered. File a writ petition. Every bar association should file a writ petition. Because we want a change of precedent from Veeraswamy case. 1991 case should be relooked into, reconsidered. And therefore, I request Advocate Tiwari to file an FIR, to try and register an FIR and in case he fails to do it, to file a writ petition. I request everybody to do that, and I hope we all will do it. And the second one is to challenge Ravichandran Iyer and the entire collegium process which has been brought by the judges' cases. Because collegium system, without the involvement of a bar, has brought us a corrupt judiciary. It cannot happen, it should not happen, and we are equal stakeholders in the judicial institution. Judiciary is not just made out of the bench, it is made by the bar and the bench. And therefore, we have to take back the position that we had. The bar has to reclaim the land it has lost to the bench. And that is where I am pointing out through this conference, the only thing that I would look forward is the time to act is now, and the only way we can act, because we work under a constitution, the only way we can work out is this, that every bar association should file a writ petition under 32, and we should pursue it until the laws of this country change, particularly the collegium system, and the fact that criminal laws should be applicable to everybody in the same manner it applies to a common man. Thank you so much.